peaceful contemplators. Get your hands and feet dirty. Rachel went to Rafah and got her hands and feet dirty. And now Craig and I believe it is our turn. Like Rachel, we may not know the impact that we have, the difference that our small steps may make, but we know that we must make them. We must take those steps. We have, in the last 5 years, walked several different paths in response to Rachel's killing. We have been in the halls of Congress, the U.S. Departments of State and Justice, and have engaged the legal system in both Israel and the United States to work for accountability in Rachel's case. On March 17th, 2003, one day after Rachel was killed, according to the Department of State, Prime Minister Sharon promised President Bush a thorough, credible, and transparent investigation into Rachel's killing. We have continued to try to hold both the U.S. and Israeli governments to that standard. After their 2003 investigation, the Israeli military concluded that the 2 soldiers who were inside the D9R Caterpillar bulldozer that killed Rachel did not see her. Those 7 eyewitnesses indicate that she was clearly visible. The case was closed in Israel and no charges were brought. The Israeli government refused to release the report to the United States government, and to this day the report has not been released to our government, though Craig and I have been able to read it at the Israeli consulate in San Francisco, also at the embassy in Washington, D.C. And there are a few members of the U.S. government who were permitted to read it at the embassy in Tel Aviv and also at the State Department. In 2004, Lawrence B. Wilkerson, the Chief of Staff to Colin Powell at the Department of State, then Secretary of State Colin Powell, wrote to our family about the IDF investigative report, and he said, "Your ultimate question, however, is a valid one. Whether or not we view that report to have reflected an investigation that was thorough, credible, and transparent. I can answer your question without equivocation. No, we do not consider it so." This position has been restated by State Department officials before a congressional committee that deals with human rights. And most recently, just this March, we received a letter from Michelle Bernier-Toff, who was the managing director of the Office of Overseas Citizen Services at the Department of State. And she wrote to us, "We have consistently requested that the government of Israel conduct a full and transparent investigation into Rachel's death. Our requests have gone unanswered or ignored. We will continue to raise this issue with the government of Israel, but unfortunately at this point we are not optimistic that the Israeli government intends to do anything further on Rachel's case or investigation." After years of inquiry, we were told by the Department of Justice that there is a U.S. statute under which a U.S. investigation could occur. We were, however, told in a meeting with the then U.S. Attorney in Seattle, Mr. John McKay, that for investigation or prosecution to happen, that the Attorney General of the United States must certify that in his opinion the act was intended to coerce, intimidate, or retaliate against a government or a civilian population. Mr. McKay stated that no U.S. Attorney General, past, present, or future, would ever provide this certification against the government of Israel. Subsequently, high-level officials at the Department of Justice in Washington, D.C. told us that there would not now, and most likely would never be, a U.S. investigation into Rachel's killing, no matter what evidence we might produce, and that in their judgment it was not the intent of Congress for the statute to be used in this way, though it has been used against other sovereign countries when American citizens have been killed and foreign militaries have been implicated, specifically against the country of Indonesia. Advised by Department of State officials to pursue the matter in Israeli courts, in March 2005, our family initiated a private lawsuit against the Israel Defense Forces in the State of Israel. The Israeli Knesset subsequently passed legislation making it retroactively impossible for Palestinians and others to take legal action against the IDF for injury that occurred in the occupied territories after September 2000. This legislation was clearly in violation of international law. In December of 2006, the Israeli Supreme Court unanimously invalidated portions of it. So now our lawsuit in Israel is once again moving forward very slowly, and we await further action there. But it is in the very earliest procedural phases still. In March 2005, joined by Palestinian families who lost family members or sustained serious bodily injury during IDF home demolitions where Caterpillar equipment was used, we also filed suit in the United States against Caterpillar Incorporated. And there's a lot of misunderstanding about this lawsuit, so I'd just like to take a minute or so to explain about it. The Caterpillar Corporation sold bulldozers and other earth-moving equipment to the Israel Defense Forces and supplied parts for previously sold equipment and facilitated maintenance of that equipment long after Caterpillar Corporation knew that the equipment was being used in a pattern of human rights violations in Palestine. Rachel was not the first person crushed by a Caterpillar bulldozer in home demolition. In fact, Craig and I, when we were in Nablus recently, went to the gravesite of one of the other families who are on the Caterpillar lawsuit, the Al-Shobi family from Nablus, in which in 2002, 8 family members were killed when a house was demolished on top of that family. On November 22nd, 2005, Judge Frank Burgess in the U.S. District Court in Western Washington granted Caterpillar Incorporation's motion to dismiss the case. We appealed that to the Ninth Circuit Court of Appeals, and in July 2007, we were able to bring our case before a panel of 3 judges. In September, the panel affirmed the lower court's ruling based on the element of political question, which really has to do with a separation of powers argument within the courts. And it was based on the fact that there is a separation of powers that prevents the courts from intervening sometimes in cases that they feel may infringe on U.S. foreign policy. And we have asked for a rehearing of that. We asked for that in October, and we are still waiting further action on the case. So I just wanted to update you on that. Despite very slow progress, we can continue to pursue this matter in whatever way we can. We feel strongly that the Israeli government must be held accountable for their past actions, even as they are encouraged to act more responsibly in the future, and that the U.S. government must meet its obligations to U.S. citizens who are killed by foreign militaries who receive U.S. aid. We have found ourselves on an unexpected journey sharing Rachel's words. And there is a play, My Name is Rachel Corrie. Some of you have heard about it. It is now traveling across the United States and Canada, and we had the pleasure of seeing it in Arabic in Haifa, in Nazareth, and in Jaffa recently when we were in Israel and Palestine. In her emails to us from Rafah in 2003, Rachel wrote, "I would like to leave Rafah with a viable plan to return. I think it is valuable to make commitments to places, so I would like to be able to plan on coming back here within a year or so." And in an email to me, she wrote, "I wish you could meet these people. Maybe, hopefully someday, you will." In September 2003, Craig and I traveled to Gaza for the first time, spent